Imagine you're at a cafe, enjoying a beer. You pour the last bit out over your ice cream and out flops something that will change legal history. It's the reason you can sue a company today if their product hurts you, even if you didn't buy it yourself. Donoghue versus Stevenson laid the foundation of the modern law of negligence in common law jurisdictions worldwide as well as in Scotland, establishing general principles of the duty of care. May Donoghue sitting in the Wellmeadow Cafe. She looks like a character from a silent horror movie. Her friend, who remains a nameless, legal enigma, hands her a bottle of Stevenson's ginger beer. It was an opaque bottle. Dark, mysterious, like a liquid goth phase. May poured, she sipped, she felt, okay, but then, the final pour. Extreme slow motion. A slimy, grey, decomposed snail slides out of the bottle in 4K resolution. It lands on the vanilla ice cream with a sound like a wet boot hitting a swamp. It was too late. Because before she could ever say oh no there's a wee ghastly beastie in my dairy, the deed has already transpired. She finds herself running towards the restroom to relieve herself of this beastly burden. You have to understand the sheer, unmitigated chaos of 1928 law. May went to her lawyer and said, I've been poisoned by a mollusk. And the lawyer said, did you buy the drink? May said, no, my friend did. The lawyer then laughed for 3 straight hours. Why the laughter? Back then, the law was a members-only club. If you didn't hand the coins to the manufacturer yourself, you didn't exist. You could find a literal kraken in your soda, but if your aunt bought it for you, the law said, sucks to be you, enjoy the tentacles. Most people would have just vomited and moved on. Not May. She sued David Stevenson, the manufacturer, for £500. The lower courts basically laughed her out of the building. No contract, no case. They shouted. The case climbed the legal ladder like a snail on a mission. It reached the House of Lords, the final bosses of British law. In the old days, if I buy a poisoned pie and give it to you, you can't sue the baker because you didn't pay him. There was no contractual relationship between May and the manufacturer, Stevenson. To the law, May was a third-party stranger. Lord Atkins said, listen up, you lunatics. We're changing the world today. I've been reading this book. It's called the Bible. It says, love thy neighbor. And I asked myself, in the eyes of the law, who is my neighbor? Is it the guy who lives next door? No. My neighbor is anyone so closely and directly affected by my act that I ought to have them in mind. If you put ginger beer in an opaque bottle, you know someone is going to drink it. That person is your neighbor. Because of this case, to win a lawsuit for negligence today, you have to prove 3 things. We call it the negligence sandwich. Duty of care. Does the defendant have a legal obligation to be careful toward you? Yes, if you're their neighbor. Breach of duty. Did they fail to reach the standard of a reasonable person? A reasonable person doesn't bottle snails. Causation, damage. Did their failure actually cause your injury? May got shock and gastroenteritis. The snail was the proximate cause. May won her right to a trial in a 3-2 decision. Stevenson died before the final verdict, but his estate settled. Decades later, in 1990, the courts realized the neighbor principle was too big. Everyone was suing everyone, so they added a security system called the Caparo test. Foreseeable. Could you guess this would happen? Proximity. Are you close enough to the situation? Fair, just, and reasonable. Does it make sense to allow a lawsuit, or would it break society? Please remember, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Every time you see a warning, may contain peanuts label or a do not drink sign on a bleach bottle, thank May Donoghue. Before her, you were on your own. After her, we are all neighbors.